We always hear that a witness. Who is a witness? How can you clearly understand the word witness? How can you simply get to know who can stand as a witness, who qualifies to be a witness, or who cannot qualify to be? So today we are still under the law of evidence 2, and we are looking at witnesses as a topic. Who is a witness? Now, by not wasting any time, let's first uh, make a distinction or a definition of who is a witness. In R versus Campbell, court held that a witness is a person who testifies in court, and in this way we run to section 117 of Evidence Act, which states that every person can give evidence in court, or any person is competent to testify in court. What does that mean? That every person, you can be called at any time to stand as a witness. In our simple meaning, a witness is that person who is called in court sometimes talk about something he or she is asked of. An example is if uh, there was killing and you find there is someone who was at the crime scene who saw someone trying to kill, uh, then you're called in court to go and speak of what you saw, which there start to say that I, Brighton, at this stage, I saw this and this happened, and this one is the one who did it. Now, at this point, they will just need you to speak or to talk about uh, the exact fact that they have given you. It's here they will direct you. This is not hearsay that you have to speak or what someone had said. Oh, this is not the opinion that you speak from your mind or from the view of your mind. Here we will speak according to the facts. If they're killing now, speak. How are they related to to the the? Of course, we shall see the types of witnesses and the styles of how we can do witness in court, the cross-examination, examination in chief. Yes. Now, they have said, Section 117 of Evidence Act states that all persons are competent to testify unless the court considers that they are prevented from undertaking the questions put in them. So here is the meaning is that every person now is considered to testify unless the court has not satisfied himself, has not satisfied itself, uh, or where the court finds that they must first take you through some of the questions. An example is like when you bring a young kid testifying over something, then the court will first have that kid question him or her and try to put that kid in the mood whether he or she is competent to answer or to give that part or to testify in simple way. Now, the word competence. Competence means that you have the ability to give out testimony. You have the ability as simple. We shall see the comparability. Then we shall get the comparability. Then we get the competence, so we see where there is a difference, where there is a distinction of the two words. As the general rule, all persons are competent to give evidence in court. That is provided as section 117, the general rule. According to NECOS, competence is the capacity to give evidence. Yes, competence is the capacity to give evidence. Comparability is where, with no question you asking, the court will refer you to testify, whether you like it or not. That is comparability. Here the law requires you to testify. There is no need for you to hold the capacity, but here it is the order where you will be forced to testify without you giving any question or raising any concern over that. Now let's look at the forms of competence and incompetence. Where can we rely that this one is competent, and where can he be not competent enough? Now when you look at section 118, it says that a witness who is unable to speak may give evidence in any other manner in which he or she can make it intelligently, as by writing or by signs. Now, not only people, now we are looking at the capacity, the weight of the capacity. Now here we see that even the person who does not speak can also give what? Can testify. Now how? Now this person will testify through writing or signatures. If that person is mentally stable or ready to testify, now he or she will give that testimony through that category. We have the case of Hamis versus Ara. The witness was both dumb and deaf, but he could make a certain noise. It was held that such a witness was competent if she could be able to communicate in intelligence way, and if she could also follow the proceedings. Now let's see the competency of children of tender years. Now a child of tender years is that one of below 14 years, and that person is young but can also go ahead and testify or give evidence in court. But in this way, we have what we call a voir dire. A voir dire is the step where the court will first bring that child, pass through some examinations, ask her or him to make sure that that child is able to know what he's talking about. Yes. In Chabajeng versus R explains who is a child of a tender year. A child of a tender, as I've said, is a child under the age of 14. However, in R versus Campbell, it was held that whether a child of a tender year is a matter of good sense or distinction of the court. What does that mean? That if the child, as I've told you, if you find a child is that of tender age, as it was discussed in Chabajeng versus R, now they will just have to understand whether the child can come out with the knowledge, have the knowledge of testifying. Now, The child will pass through what we call a voir dire. The court must conduct a voir dire to determine the child's intelligence or the oath, the nature of oath, to make sure the child understands the session he or she is going in. It was discussed in Uganda versus Oloya. Uganda versus Oloya. Now we have the competence of the accused persons. Now, that is a crime or what we call uh, 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 persons in the same crime. Persons in the same crime. What does that mean? And let me first give you the example. It's why you find I was caught in a certain case, or I did something with my fellows. So when they bring someone among us and it testifies that yes, he did it, then there is no question. All of us will be convicted. All the same. So for that, you will see the case of Arabasa Sandala. The accused had given evidence on oath implicating on co-accused. It was held that such evidence was good and accused person is competent for defense, not for the prosecution. So here the principle is the accused person, or what you call the accomplice is competent witness against an accused person. Yes, you are competent, or the accomplice or the accused person is competent against his co-accused. Section 132 of Evidence Act provides an accomplice shall be a competent witness against an accused person. That is the law. However, somehow, somewhere, the court must take what we call corroboration in this. It is not the matter of that if someone comes out and say or testify that it will go. No, there must be some corroboration. We shall see collaboration and reaching collaboration as the topic, but collaboration means you group other aspects. This person did something, but he used another thing to make sure that the crime happened. So we get in touch with other material, let's say the material evidence, like the weapons used and other, and we make sure we group all of those to come up in one transaction. Yes. Competence of insane witnesses. Who is an insane person? An insane person is a person who is not mentally stable, a person who is lacks some thinking somehow in simple understanding or in simple explanation. But the insane person, to be clear, to be taken as specify that person sometimes may be okay, you find another time is not okay. So when you find that person when he's okay and it testifies and it testifies right, then the testimonies will be taken. In our verses here, a lunatic was an eyewitness of a man slaughter. Medical evidence showed that the witness suffered from delusion, but this did not affect his understanding of the oath. It was held that he was a competent witness. I understand. Competence of the spouse. The general is a wife or husband of the accused person can be a competent but not comparable witness for the prosecution. So, in where you find a spouse is a married person. A spouse can testify against another spouse only when he or she is allowed by other spouse. This basically works uh, in instances of criminal, I mean of this instance works on in criminal. Yes, the law says, the Bible says that if you're married, you become one. But I want you to put in your mind in instances of rape. Do you know that a man can rape his own wife? And how does this happen? When a man forces a lady or to penetrate or to have what we call carnal knowledge, means there is no consent from the lady. So in instances like a rape, then then the man can come out. I mean, the lady can come out and testify over the man. Section 120 of Evidence Act provides that who is spouse, and it was explained well in R versus Sampaio. The court held that the wife of the accused was a competent witness for the prosecution, even though she appeared to testify without the consent of the husband or the accused. Yes. Now, let's look at comparability. What is comparability? This means a witness shall not be accused from answering any question as any matter relevant to the fact in issue. He must answer the relevant question asked. The general rule is under section 131 of the Evidence Act provides that a witness shall not excuse from answering any question as any matter related to the matter in issue on grounds that the answer may incriminate him. So here we are saying incomparability. It is where once you brought testify over any matter, you have no question to answer or to reject, which means you are always forced to come and give evidence in court. But this even uh, the general rule is well elaborated and it has its exemptions to the above rule. Basically, when you see section 119 talks about the magistrates and judges. Yes, judges, we know that they know facts. All the magistrates, they know facts, but they will not be comparable, or they will not be forced to come and testify over what they know. We have the marital privilege. Section 120 shows that the wife or husband of the accused is not comparable to testify against the other in criminal proceedings. In criminal proceedings, as we have said, let's say something, yes, but to remind my words back, let me first go back to section 120, which talks about the spouse. Yes, we see that the spouse can testify, but she is not forced to testify. But here, but here, uh, when you look at under the exemption from the general rule of the comparability, they are saying that the wife or husband of the accused is not comparable to his wife. He is not forced to come and give evidence. However, he can or she can. We have professional privilege advocates. That is section 135. This is why you find you're a lawyer. You're studying, you're standing in behalf of the client, and we presume that the client must state the facts. But if time comes, the judge or any person cannot force you to come out and speak out something over those things that you know about the client. Never, you can't be comparable. You have that privilege. We have, when you look at section 123, it talks about privilege of the official communication, privilege regarding information as communication of the offenses. This is why you find a communication or information from the defense or the yes from the security. That's why you find the security cannot disclose the information because it may lead to some circumstances, and there they cannot force to come out and give those information in regards to the same. Now let's go and see the examination in court, because when there is examination in court, then it means the witnesses are the ones examined in court. Section 134 requires witnesses to produce and examine in court, whether orally. In oral examination, a witness after taking an oath is obliged to answer questions to him or her. This is where the witness will first take an oath. Then after, he or she will be asked orally, did you see him? Are you sure he is the one? Can you clearly identify the person whom you are telling us that you saw? Then the witness may start say, he is the one, is black like the way he is. I saw a person who is tall as him, and according to what I'm seeing, I saw the tattoo on his left hand, and this is the tattoo, and this person had long hair, and clearly he is. So that is oral examination or examining the witness. We have examination in chief, section 136A of Evidence Act. So, require examination of a witness by the party who calls such witnesses in court. Cross-examination. The witness who had been sworn may be cross-examined by advocate from the opposite. Now, cross-examination, the witness can be questioned from the opposite. But here, at examination in chief, you are just your advocate can leading questions can ask you, can you please tell us what you saw? Now, cross-examination, the other counsel or the opposite counsel can also question you. That is under section 136. We also have what we call re-examination. Section 136, 3. This is basically examination of a witness after the cross-examination by party who called the witness. However, at this stage, leading question may not be asked under section 140. Leading question are those suggesting answers which the person putting be to wish or expect to receive. So, in this way, as we have seen, a witness is competent and comparable. Being that he or she is written is competent and comparable, then he goes ahead when the time comes that he has to be asked to give that testimony, then he's asked or is arranged in different way, the cross examination and the examination in chief. Thank you for watching. Thank you for listening.